Yes, my people. Once again, it's Rockstar 860 TV. And today, this morning, June 12th, we are do a little recap of what happened yesterday, June 11th, during the Vibes Cartel and its co-accused retrial hearing to see if there'll be a retrial or an acquittal for him and his co-accused. Yesterday was a very eventful day. A lot happened yesterday. John Clarke, a part of the defense team. I think he is Andre St. John's or Kerry Jones' lawyer. I'm not sure. But he took the center stage and he performed. He did his work, what he's getting paid for. He attacked the prosecution and he made valuable and impartial statements to the judge. Know what I mean? Considering and concerning this case. He spoke up for the men's constitutional rights. He spoke up for the men's right to a fair trial, meaning time and with proper evidence, all these things. That constitutes a fair trial. Time of a trial. How long it's going to take for these men to get a retrial. Them can't just be sitting in prison because they're supposed to be in a holding, but they're in prison 13 years now. So how long will this retrial take? The next 10 years? The next 5 years? The next 15 years? What? They might make him do 17 more years for getting 30 years in before them the retrial? Because we know how slow Jamaica is. We're not blaming the people, but we're blaming the system. Because the system doesn't care. We see murders happen and murders take long to go to trial. And that's just a regular murder. Imagine a retrial. And we knew, Privy Council said, if a retrial was to happen, it's supposed to happen within a fairly decent and fair amount of time. Know what I mean? Because this is a process that's been going on since 2011, people. 2011, 13 years ago. Know what I mean? Now we're in 2024, almost going to 2025, because we're halfway through the year already. Know what I mean? But let's see what happened in court as we go.
Reminding viewers that to order a retrial, the court has to be convinced it's in the interest of justice. So John Clarke, speaking for the appellants, was arguing that it would not be in the interest of justice. Remember now, you have a constitutional right to a fair trial within a reasonable time, and he raised this issue. And I can tell you, Archie, it's clear this is going to be one of the pivotal issues in deciding this case. Look at the timeline here. The men were arrested in 2011 for the murder of Clive Lizard Williams. They were convicted in 2014. We're in 2024 now. It's taken 10 years for this appeal process to take place. And the question is, when would a retrial take place? How long would a retrial take? And would the men's right to a fair trial within a reasonable time be breached if this retrial is ordered? Now, there was an issue of delay that didn't go down great with the court. Now, John Clarke was making the point that we have a systemic problem of delay. And he started to make the point that the Privy Council, when it delivered its ruling in March, delivered that judgment only a month after it finished hearing. Justice Margaret MacDonald Bishop was not amused. She said, don't go there. She stopped him right in his tracks. And she was suggesting that it really is an unfair comparison. She said in the local court of appeal, many issues came to them in this matter that they had to deal with. I went back and looked at the judgment. There were 15 grounds of appeal grouped under 6 headings. And she pointed out that the Privy Council just decided that it was dealing with one, which is, of course, the issue of jury misconduct. And one of the issues here really is, I think a lot of people don't realize our judges can't respond in our system to criticism in the public domain. You know, she actually said that the words she used were that the court does not have a microphone to answer public opinion, and this really is the only way in which they get to speak, which is within a hearing within the court. So she really was saying it's an unfair comparison. Don't make that kind of comparison. And the council then made sure to, backtrack and indicate that since the judgment was handed down by the Privy Council, the Court of Appeal certainly has not delayed or dragged its feet at all in the matter.
So where does the case go tomorrow? Is there any indication of that?
Yes, we're going to continue to hear the lawyers for the appellants. John Clarke, more than likely, will continue to make his submissions. He's going to now go into great detail in terms of each of the factors that they are saying would make a retrial unfair and how each of those factors would affect each of the men, each of the appellants in this matter.
As in all 15 grounds?
No, I doubt that, because one of the things, again, remember in these hearings is that what happens in court is really just a little slice of all the material before the judges. They get tons and tons of submissions and paper that they're going through in private. So what we are seeing really is a kind of summary of the main points, as well as the judges asking questions on any issues that seem perhaps questionable to them in the submissions that have been made. After the appellants finish, then we hear from the prosecution.
So interesting days ahead. Certainly already interesting days in the 2 days so far, and this continues until the end of the week.
And the judge has said several times it is not going beyond Friday.
All right, so we'll find.
Thank you, Miss Miller. That was a recap of what happened in court yesterday from Miss Dion Jackson Miller, an attorney in Jamaica. Know what I mean? And one thing I can say, that was TVJ, but I've been looking around for news on the coverage of this trial from yesterday, and it seems like the media houses in Jamaica are starting to just throw out something real quick and then delete it later, because you can't really find anything. This is a major case. The world is looking in on this case, and you can't even find anything of prominence to really talk about. You know what I mean? So when the court is talking about the media to be mindful of how they're covering this case, it's like the media is not even covering this case. It's like they're just looking for sensationalizations points to put out. You know what I mean? It seems like if it's not going good for the prosecution, they don't talk about anything. You know what I mean? They don't talk about fairness. It's like they them slight of coverage. So we're going to see when the prosecution is putting on their case, all the media houses writes about what's going on with their presentation. Because when Vibes Cartel lawyers or the defense team is putting on their presentation, it seems like they're only looking for the sensationalized parts to talk about. You know what I mean? So I don't know. Like we always said, the media houses in Jamaica doesn't really cover Vibes Cartel with fairness. They only cover him with negativity or the worst things or the bad things. Like them just want to sell paper or get views online from the news outlets. You know what I mean? And that's not really fair to Vibes Cartel or its co-accused. It's like them they exist in this. It's like they're pieces of shit, so to say. Excuse me for my language, but that's how it is. Know what I mean? But big up John Clarke. He's doing a great job. He did a great job yesterday. They say Isaac should be speaking today. So we're going to hear what Isaac has to say. Know what I mean? And I'll be reading some articles that I found here and there. Maybe the Observer, maybe the Star. But I look on the Gleaner and their site don't even come up. It's saying error. You know what I mean? Like the site just popped down or them dismantle the site or something. I don't know. That's gleaner.com. I not talk about Glean up on Instagram. You know what I mean? So I'll find some articles and we are going to read up about what happened yesterday. Yeah. So the first article I'm going to read is from the Star. It says, Vibes Cartel says retrial would hurt his dependents. You know what I mean? It's by Tanisha Mundell from the Star. So, incarcerated entertainer Adidja Vibes Cartel Palmer has complained that a new trial will hamper his ability to provide for his 17 dependents, meaning his kids, his mother, his parents, his baby's mothers, all those who depend on him. Those are dependents. Them depend on him as the breadwinner for his family or those who are around him. Know what I mean? The entertainer, who along with his three co-accused are awaiting a decision on whether they should be retried or acquitted of the 2011 murder of Clive Williams, submitted in an affidavit before the Court of Appeal that he is the sole breadwinner. The matter was highlighted by Acting Director of Public Prosecutions Claudette Thompson, who yesterday asked the court to strike that portion from his affidavit as being irrelevant. Justice Marvin McDonald Bishop, who, along with Justices David Fraser and Paulette Williams is hearing arguments to determine whether there should be a retrial. However, ruled that the portion should remain. That's a plus for Kartel. Yes. He is talking about the ordeal. We won't strike out his facts that he has 17 dependents. We will see how it comes out in the wash, as they had put it. They will bring it together, McDonald Bishop said, noting that the court will decide what weight to give to the argument that a new trial will affect his ability to earn and support his family. Similarly, Vybz Kartel co-accused Kerry Jones also submitted that a retrial would present a financial challenge for him. I am advised by my current lawyer and do verily believe that the Jamaica justice system does not afford any opportunity for me to get costs thrown away from the first trial, Jones said in his affidavit. Thompson also took issue with his argument, but the justice, McDonald Bishop, said if him lawyer tell him that he won't get back any money for the first trial, I don't think anything is so wrong with that. He is not compensated, and now he is saying he want the money to prepare for his new trial. Leave it alone. It is an effect on him to face a new trial. They can speak to any hardship they face, the judge further remarked. Those are positives for the defense. And the news not talk about this. This are the men complaining about finances to go to a trial again, and the first trial took 64 days. Them got to Privy Council, and Privy Council is not cheap. Privy Council is very expensive. You know what I mean? So it's like the DPP don't want them to talk about them financial hardships. You know what I mean? But the judge say no. That's facts. Those are their facts. Those are their truths. Or will they pay for this? We have to take that into consideration. You know what I mean? So leave it alone. It is an effect on him to face a new trial. They can speak to any hardship they face, the judge further remarked. Vybz Kartel, Jones, Andre St. John, and Sean Storm Campbell, as we know, they was convicted in 2014. The convictions were thrown out in March. Know what I mean? And we're here trying to see if there should be a retrial or a total acquittal. Know what I mean? So that was positive for Vybz Kartel and his co-accused. Know what I mean? People, there is positive news out there for Vybz Kartel and his co-accused. But if you don't look for it, you won't see it. Because they're going to put it in the finest or smallest print and put it in the smallest or finest places. Now, I mean, they're not going to highlight it. They must keep it quiet. But you see the negative parts of things, you see the parts where it look bad for the co-accused and Vybz Kartel, they're going to highlight those parts more. But I'm seeing it from yesterday till now, it's more positive for Vybz Kartel and the co-accused. You know what I mean? A lot of times, the DPP and the prosecution has been turned down for the objections. You know what I mean? Remember what Alexandra said when she did her interview. They're happy with how the things are going. The things they want presented is getting accepted. So they're happy. They said, remember she said, if there's any problem, they will object or they will deal with the matter at hand. So we hear the defense doing their job. We hear what's going on, but we just have to find it. Don't get miscued and don't get blindsided by all the negative. That's what they want. They want to talk about the worst, but you have to search. The positives are there. And to how it's looking, the defense, John Clarke, those who have spoken already, are doing a great job. You know what I mean? That's what it looked like. They're highlighting major points: constitutional rights, rights to a fair trial, rights to a timely process for a fair trial, rights to know how long a retrial takes in these matters. They're highlighting what they're supposed to highlight. Don't get blindsided. Don't watch because they didn't accept liquor vibes part when him say about his father heart won't stand up or his grandmother's prayers. That's minimal. Highlight the fact that the judge accepted the hardships of these men being behind bars 13 years and wondering how they're going to pay for their legal fees. This next article is from the Observer, Jamaica Observer, written by Alicia Dunkley Willis. Attorneys argues evidence against Kartel and co-accused need to be considered individually. Now this is the the great John Clarke, who we heard about yesterday, who did his great job. So let's read into and see what he did. Defense attorney John Clarke on Tuesday described the technological evidence against entertainer Vybz Kartel and his co-accused as very important and said if the appeal court rejects the defense arguments that it would not be in the interest of justice to order a retrial of the men, it will have to consider the evidence against each appellant individually, since the case against each of them might ultimately lead to different conclusions. I mean, in a seminal judgment in March, the Privy Council quashed the murder. We know all of these things, so we just go to the gist of it. Know what I mean? The same Privy Council trolled. That's why we write here. Know what I mean? So we're not gonna go through all of that. The prosecution case had been that the correspondence and communication media, taken as a whole, with the evidence of the sole eyewitness, proved the fact of the dirting. The reason for the dirting, the method of disposal of the deceased body, and the identity of at least one of the killers, namely Palmer. The defense had argued that the evidence was obtained in breach of the constitutional rights of the men and was therefore inadmissible. Tampered evidence, no warrants to get the tampered evidence. You know what I mean? But the British court offered no conclusions whatsoever in the appeal, asking it to rule on whether the original trial judge should have excluded. Hold on. Let me read that again. But the British court offered no conclusions whatsoever in the appeal, asking it to rule on whether the original trial judge should have excluded the telecommunication evidence relied on by the prosecution. Instead, the Privy Council said it would defer any answer to the constitutional issue to another occasion where it can hear the mind of the Jamaican judiciary. I guess, I don't know. I don't understand that, so I'm not even going to try to pretend like I know, but I know it has something to do with the phone and how it was obtained and what they did with the phone after it was obtained through chain of command, through this person using the phone. I don't know how they did it, but they did it. That person using the phone, them said they use it for one day, but how do we know? You know what I mean? All these rigmaroles and foolishness. That's what the prosecution did. And now we are in this big pot of gumbo. I try to say we're in the pot of gumbo. You know what I mean? But on Tuesday, Clarke, addressing the appeal court panel comprising Justices Marvin McDonald Bishop, Paulette Williams, and David Fraser, said, "We will try to point the court directly to where, in the material evidence, there is the statement from the accused men and, importantly, what the sole witness had said in relation to each of the accused men. We make the point that each of the cases for the accused men need to be considered individually in making the determination whether or not a retrial should be ordered in relation to each of them, because the case against them may ultimately lead to different conclusions. The case for each defendant would have to be considered individually if a retrial was ordered." Clarke, however, noted that this would only be applicable if the appeal court rejects the overarching argument of the defense, which is that by the mere passage of time and the attendant prejudice in light of case law and the constitutional guarantees in this country, it would not be in the interest of justice to order a new trial. Clarke also addressed the chronological of events in the case. He said that the date of the chop-up text, which was purportedly sent from Palmer's phone to a third party communicating that Lizard was dead and would never be found, was dated July 6, 2011. However, the send date of the message predated the incident date by more than a month. Really? On the indictment, the men who were accused of committing the crime on August 16, 2011, and taken into custody September 30th, 2011, the attorney noted. In inviting the court to consider what obtains when ordering a retrial, particularly in circumstances where conviction has been quashed, Clarke pointed out that the appeal process has languished for over 10 years and asked, how can the men have a fair trial after all this time? Jano Star. If it was me, what would I do? I'd want to fight for my freedom, fight for my life. Said Clarke, while different state organs might have justified reasons for taking time to examine the matter, let us not forget that all materials times the appellants were incarcerated while the wheels of justice slowed eternally. Sorry, let me read that again. Let us not forget that at all material times the appellants were incarcerated while the wheels of justice slowly turned. According to the attorney, there is a prima facie breach of the reasonable time standards guaranteed by the Constitution in addition to the breaches of the fair trials rights of the men. Justice McDonald Bishop, commenting on that issue, said, the Crown, which is the prosecution, will have to tell us why, given the two breaches of their fair trial rights, a retrial is justified. You hear what the judge said? The Crown, which is the prosecution, which is the DPP, better have a good argument to tell her why them fi have a retrial when the men's constitutional rights were breached. And the constitutional rights of any citizen of any country is the law of the land. I mean, more than just regular law. This is the Constitution, the law of the land. In the meantime, Clarke, in referencing the affidavits filed for the men in which they say they are broke and unable to foot the cost of further legal battles, said, there are some concerns about the legal aid system, adding that the four appellants are already concerned about the reduction in the number of jurors from 12 to 7 based on changes in the law since their original trial, much less being tried by a single judge. Know what I mean? So all those who said them is a one judge, no. For them thing gone down to 7 jurors. Before 2011, 2014, it was 12. After Kartel case, them change the law, it's gone down to 7. You know what I mean? Once again, Kartel. Oh my God. We are submitting that the effect of a retrial order can cause prejudice to the appellants, the attorney said, while further pointing out that in light of the admission by the Crown that some witnesses might not be available, a further breach of the rights of the appellants was being created. So these people are trying to put on the money upon trial again, and them don't even have witnesses. So what are they going to do? What are they trying? According to Clarke, in a country where the trial list of the Home Circuit Court is long and a retrial likely to take more than the original 64 days, which would prolong the ordeal of the men, the rights of other accused whose matters might be stood down to allow for the retrial would also be breached. So them are going to stop other people who are look for them day in a court just for try cartel and them for money. Really? At that demand do? Stop other people rights to justice just to try convict one man? That's crazy. As to the findings of the Privy Council regarding the majority verdict, Clarke said its pronouncements on whether directions by the trial judge could have cured the contamination of the jury, which led to its decision to quash the convictions, was an issue with which the defense had grappled and which the court needed to resolve. It is important to the court for considering where the interest of justice lies, given the board's observation that no directions by the judge, no matter how focused and firm, could compensate for the real risk of contamination. The board, in considering whether directions could have cured the issue in that case, held that in any event a direction, however focused and firm, could not rectify the damage to the integrity of the trial, the attorney pointed out. Meaning said no matter what the judge said, the people them already have their mind make up. And that is it, and that is that. Now I mean? So yes, my people, that was a recap for day 2. Now I mean, we see what's going on. We just have to just watch and see what's going on even more. So we see John Clarke put on a great show for the defense and really presented what he wanted to say the right way. Now, I mean, it got contentious at points between him and the judge, but I just law, I just courtroom, I just the back and forth between the prosecution, the defense, and the judge who are trying to be the straight line in the middle. You know what I mean? So we just watch, see what I go on for today, day 3, and then later in the day we come and we analyze what happened for day 3. Just go round on your lives and where you go up on Gaza Uncle, you know what I mean, Real Vibes TV, DJ Did, Unruly Tash, Brando Music Reviews. And in one of these places, I might forget somebody. Don't be mad at me. I'm just doing this off the whim. You know what I mean? Off the top of the dome. You know what I mean? So don't really be mad at me if I forgot you. But that's what I have to say. One up, got up. I'm out.